Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a big ruling from the Supreme Court yesterday, and a whole bunch of people sent this to me. Michael sent me a link to the National Review story, A Win for Civil Forfeiture, but the Supreme Court is skeptical, by Dan McLaughlin. And you have to understand, even though the court ruled pretty much the way we thought they would, there's a light at the end of the tunnel. We think. So the Supreme Court, in a case called Cully versus Marshall, handed a modest victory to aggressive civil forfeiture schemes, but the court's lineup may indicate trouble ahead for civil forfeiture at the court in the near future. Now, this case involved two Alabama cases where police arrested drivers for having drugs in cars they didn't own. They seized the cars and then required the owners to wait months to get their cars back. In one case, for instance, the driver was the owner's college-aged son who had the car on campus. In the other, it was the owner's friend who had borrowed the car. The owners argued that due process requires not only a prompt hearing on whether the government could keep the car permanently, but also a preliminary hearing on whether the car could be held by the government pending the final hearing. Now, the court voted 6-3 for the government, ruling that due process requires only a prompt hearing to determine the propriety of the seizure and no additional preliminary hearings. And so pretty much we thought that was what was going to happen. We figured, okay, because previously they've ruled on the issue of somebody who borrows someone else's car and then the car gets seized when the borrower does something wrong in the car. They've already ruled on that. And so you might go, what's going on here then? Well, in the opinion of the court, for the majority, they ruled that there are cases going back to 1983 and 1986, which were both decided in the heyday of enthusiasm for expanding forfeiture. They concluded that the question was already settled, and the plaintiff's argument for a separate preliminary hearing appears in many respects to be a backdoor argument for a more timely hearing so that a property owner with a good defense against forfeiture can recover their property more quickly. But the court's precedents already require a timely hearing. Question is what's timely, but the court refused to engage in a policy-based balancing test, this being one area where the court's due process precedents, wisely or unwisely, leave a lot of policy judgments to the court. So they talked about history, and they talked about since the founding era, statutes have authorized the government to seize personal property and hold it pending a future hearing without a separate preliminary hearing. For example, the first federal forfeiture law, which dates back to 1789, the Collection Act of 1789, authorized the civil forfeiture of ships, goods, and merchandise involved in suspected violations of the customs laws. Many state forfeiture statutes from the founding period similarly did not require a preliminary hearing before the actual forfeiture hearing. In addition, when the 14th Amendment was ratified in 1868, Congress did not require preliminary hearings. In 1864, for example, Congress provided that goods seized under a new revenue law should remain in the care and custody of the government until final judgment in a forfeiture trial. Many state forfeiture laws from around the time of that 14th Amendment likewise did not provide for a preliminary hearing. Petitioners and their amicus brief friends, it says they're amici, but, or would it be amici? It's Latin, so how do we know? Do not identify any federal or state statutes that, before the late 20th century, required preliminary hearings in civil forfeiture cases. So this argument that you're entitled to this extra hearing does appear to be novel. There's not really any grounds for it, other than it just might make sense. So that's always a dangerous thing, to go before a court and say, well, there's no laws on this, there's no case law on this, but we just think it'd be a good idea. In the immediate term, therefore, civil forfeiture reform will have to come from legislatures, not the court. But Gorsuch and Thomas signed on to an opinion arguing that the court should reconsider in a proper case whether modern civil forfeiture comports with the historical precedents. As commonplace as these civil forfeiture laws may be, most are pretty new. As part of the war on drugs in the 70s and 80s, Congress began enacting sweeping new civil forfeiture statutes, allowing the government to seize and keep the proceeds of drug crimes and the personal property used to facilitate them. So law enforcement agencies have become increasingly dependent on the money they raise from civil forfeitures. Those incentives also appear to influence how they conduct them. Some agencies, for example, reportedly place special emphasis on seizing low-value items and relatively small amounts of cash, hopeful that their actions won't be contested because the cost of litigating to retrieve the property would be more than the value of the property itself. Historical traditions suggest that post-deprivation civil forfeiture processes in the discrete arenas of admiralty, customs, and revenue law may satisfy the Constitution, but the general rule remains that the government cannot seize a person's property without a prior judicial determination that the seizure is justified. It is far from clear to me, that's a justice writing this, whether the post-deprivation practices historically tolerated inside the admiralty, customs, and revenue contexts enjoy the sanction of settled usage outside them. In the past, it seems the government could confiscate only certain classes of property. So, for example, admiralty statutes regularly authorize the government to seize and pursue the civil forfeiture of the instruments of the offense, like, say, a ship used to engage in piracy. So Gorsuch cited the necessity of seizing a ship before it could sail away, for example. So he concluded, in this nation, the right to a jury trial before the government may take life, liberty, or property has always been the rule. Yes, some exceptions exist, but perhaps it is time for this court to examine more fully whether and to what degree contemporary civil forfeiture practices align with the rule and those exceptions. In future cases, with the benefit of full briefing, I hope we might begin the task of assessing how well the profound changes in civil forfeiture practices we have witnessed in recent decades comport with the Constitution's enduring guarantee of due process. So you got two justices who signed on to that opinion. But if you take the three justices who dissented, you suddenly have got five who appear to be against the general scheme of civil asset forfeiture as it is currently practiced in America today. That's a good thing. I should point out, however, I often see people say, I am guaranteed life, liberty, and the pursuit of happiness by the Constitution. Well, the phrase life, liberty, and happiness comes from the Declaration of Independence. In the Constitution, they changed the last one to life, liberty, and property. Property. And by the way, your pursuit of happiness is kind of hard to define. I'd rather have my property than give up my property and have the right to pursue my happiness. So keep in mind life, liberty, and property, Constitution, life, liberty, pursuit of happiness, Declaration of Independence. But what we're getting at here is the court ruled pretty much the way we thought they would. They were going to say, hey, car got grabbed because he used in a crime. Ain't nothing wrong with that as long as people get a hearing down the road and they can make their argument later. And how prompt is prompt? No one really knows. It depends on the circumstances. And so I've heard stories before where they'll see someone's car and not do anything for months and months and months. And someone's going, well, when do I get my car back? Don't worry. We'll send you a notice when we decide we're going to have a hearing. And so I've heard of people on many occasions filing lawsuits to get their hearing. And that would seem wrong. But the Supreme Court saying, well, but all you're entitled to is that one hearing. And the one hearing about whether or not you get to keep your stuff just has to be prompt, okay? But when the court, in an opinion there, writes and says, by the way, we'd like to take a look at this if it was properly briefed and before us, they don't do that a lot. They don't do that a lot. Usually they take a look at the narrow issue before them and make a ruling and leave it at that. And so could they have come out and called the entire forfeiture scheme wrong? They could have, but they would say, but it wasn't really presented to us in that way. And these might not be the best cases to show how bad civil asset forfeiture is. A better case might be Stephen Lara, the Marine who was pulled over out west, and a cop goes, you got cash on you, I'm just going to take it. I'm sorry, but I got to take your money. Whole thing caught on camera. He hadn't done anything wrong. In fact, he was pulled over supposedly because the officer said he might have been following another vehicle too closely. And it was all part of their updated traffic pattern control situation there. When the Institute for Justice got involved and made a lot of noise about this, they gave his money back really fast because even they realized how bad that looked. To take the money from a Marine at the side of the road, and they said, we've got nothing on you other than you're carrying cash. And he said, I got a perfect explanation as to why I'm carrying cash. I can explain it to you. We don't care. We don't believe you. And because he couldn't convince them at the roadside that his money was innocent, they took it from him. That's a case that should go before the U.S. Supreme Court. Because how do you justify that? How? And so Gorsuch, in his opinion, which had another justice concurring with him, said, we're ready to look at this. Someone bring us a case. That's clearly what they're saying between the lines. You have to understand the Supreme Court's not going to come right out and say it directly, but they're saying it about as directly as they ever will right here. So right now, the state of civil asset forfeiture in America has not changed. They simply underscored previous rulings they've made in the past, and they tended to do that. And I said, these are car cases. These are cars that were seized by the cops after someone who borrowed the car used it to commit a crime. Okay. They've already seen that case. They've already ruled on that case. But now they're signaling, but we want to see another civil asset forfeiture case, and we want to see it briefed properly, particularly on how it's evolved recently with this war on drugs. So, Michael, thanks for sending that. Everybody else, thank you for sending it to me. A win for civil forfeiture, but the Supreme Court appears to be skeptical. Good things might be on the horizon. National Review published that by Dan McLaughlin. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Red meat is not bad for you. Now, blue-green meat, that's bad for you.